Welcome to the Half Empty, Half Full Consumer Advocacy Radio Show. Listen in nationwide on the Tan Talk and Starcom radio networks with your host, Lori Zook, the consumer champion. Each week, we'll be discussing problems and solutions, changing negatives to positives, and helping you, the consumer, to learn something new. Get smarter faster and avoid scams and fraud. All opinions are that of the host and guests, and all shows are for educational purposes only and not to be construed as legal advice. Here's your host, Lori Zook.
And welcome to the show. My guests today are repeat guests. They've both been on the show before. I have consumer advocate Bob Hurt, and I have Storm Bradford of Mortgage Fraud Examiners. And we're going to be talking about a hot topic, securitization audits, and what the truth is concerning them. So I'm going to start with you, Bob. Just give our listeners a little bit about yourself and your background.
I spent years in the Navy and years after that in the computer industry. I retired from that in 2002, and suffering for having nothing to do, I began investigating law issues. And so I write law commentaries and articles and create a website or two from time to time. Most recently, the Mortgage Attack website, because I took a big interest in mortgages.
All right, very good. And Storm, give us some background about yourself.
Well, I run a couple of companies. One's a litigation support company that I've had for over 35 years now, how we train attorneys on how to win cases. And out of that, we formed another entity because a few years back, about 10 now, we got a bunch of phone calls from attorneys around the country. How do you win these foreclosure cases? So thus came about Mortgage Fraud Examiners.
All right. Now, today's topic is the securitization audits. I'm going to start with you, Storm. What are they, and what is their purpose?
Well, for the lack of a better word, they're when you ask what they are, they're basically worthless. A securitization argument in and of itself is a useless argument. It's basically only a stall tactic. So if securitization arguments are nothing but a stall tactic, why would somebody want to use a securitization audit basically just to stall a foreclosure when the outcome of a homeowner is to basically save their home, not just stall the foreclosure and then unceremoniously be thrown out afterwards.
Right, and I'm going to kind of add to that because in last week's show, I had Bob on as a guest, and if you have attorneys that are just taking the homeowner's money and they're just stalling it out, some of them think that they're doing their job by stalling it out until either it forecloses or it's, goes up for short sale or deed in lieu, correct? So it's just a stall tactic.
That's basically the line that they give the homeowner, because at the end of the day, when the homeowner gets thrown out of their house, their lawyer's fallback position is to say, well, hey, look, wait a minute. I kept you in your house for a couple of years. What are you complaining about?
At almost the same cost of the mortgage, I think, in a lot of cases, correct?
Absolutely. There's a lot of attorneys that we've seen have charged upwards of $40,000, and every homeowner they represented has lost their home to foreclosure.
Horrible. Now, Bob, you recently wrote an article on WordPress. Tell me about why you wrote that article on securitization audits.
I posted that article at bobhurt.wordpress.com. It's called How to Get the Benefits of a Securitization Audit Free. The reason I wrote it is to make fun of securitization audits as being exactly what Storm said, an absolutely worthless waste of money and of time. Because the truth is, what a securitization auditor does is he goes and gets the pooling and servicing agreement, makes a copy of it, and tries to find out who assigned the note to whom in the process of securitization. Well, that's usually a fairly trivial thing to do, because a person can get the pooling and servicing agreement himself and the 424B5 report himself from the Securities and Exchange Commission website. And if he wants to know who owns his note, he usually can go to the Fannie Mae or Freddie Mac websites and type in his loan number, and it'll tell him whether they own it, and they own about 80% of them. So it's completely ridiculous. And furthermore, because many of the notes that are put into securitization trusts have been endorsed in blank. A blank endorsed note is a bearer instrument, and whoever has it in his hand can enforce it, so it doesn't matter what the chain of title of ownership of the note is, or who the assignor was, or because we don't know who the assignee is, it was endorsed in blank. It just doesn't matter. So all of these things mean that the securitization audit has no value. Therefore, if somebody is being charged $1,000, $2,000, $3,000, $4,000, $5,000 for a securitization audit and a chain of title audit, he's being scammed. And as a consumer advocate, I don't like seeing people get scammed.
Right. Now, and Storm, I know on previous shows, I believe you talked about how federal courts have ruled it doesn't really matter how it was securitized, correct?
That's correct. Yeah, securitization is really nothing more than I originated the loan, I made the loan, and now I've sold the note to you, and you now own the note, and you can basically do with it as you so please. I mean, securitization has been going on in this country since the 1700s. So it's not something that's new. It's something that's done every day. It's just, as Mr. Hurt pointed out, it's just a lot of noise. It's really not of any help to a homeowner whatsoever.
Well, that's a good term, noise, because I think that because most homeowners, most consumers, they do not know what either of you two know. And Bob, being a consumer advocate, you don't charge anybody to talk to them or help them or write these articles. You're actually, when I've read your articles, they're very helpful for a consumer who uses due diligence. That's my favorite expression now, due diligence, because most people don't. And they don't necessarily know what source to go to try and find out what the real information is. They tend to go to attorneys that write these blogs to kind of benefit themselves and bring them more business, whereas you have no interest, correct?
That's right. I don't sell anything, and the one thing that I have become devoted to is something that Mr. Bradford has made, I guess you'd say, his mantra. There is no substitute for what, Storm?
Knowing the law.
Right. There is no substitute. And so I constantly encourage people to study the law, to learn the law, learn the rules of court, learn the rules of evidence, and learn these regulations that have to do with securitization, like Regulation Z, Regulation X, that have to do with what borrowers can do to defend themselves and what their obligations are that have nothing to do with securitization, but take the place of worrying about securitization.
Okay, it almost sounds to me like you should be teaching attorneys.
Well, that's what Storm's profession is, and thanks to his mentoring, I've learned quite a bit that attorneys should know as well.
All right, now, Storm, who sells securitization audits? Even if we know that they're worthless, who is selling them? Are they people that are qualified to do that?
No. I mean, it all started, just a quick background, when mortgage brokers couldn't sell mortgages anymore because of the housing market going down. They needed something to make money, and they all started doing loan modifications. Back when they first started, we saw companies, these brokers, charging as much as $10,000 to do a loan modification, and just back then, as is now, most people don't get them, and they keep the $10,000 and tell the homeowner, sorry, the bank won't do it. Well, all the complaints started coming into the attorneys general. The attorneys general started having laws passed in every state that you couldn't charge an upfront fee to do loan mods. Well, then, to overcome that, they all started doing, quote, forensic loan audits, which most of the time they were doing nothing. It was just a cover so they could charge an upfront fee under the auspice that they were doing an audit. Well, we did a press release on that saying it was a scam. The Attorney General of California at the time, who's now Governor, Jerry Brown, he picked it up and basically almost read verbatim from it, and it became common knowledge that forensic loan audits were scams. So then all of these individuals said, well, this isn't working. We've got to have a new scam to sell, and that's now the securitization audit. So it basically started from its humble beginnings doing loan modifications to now doing securitization audits. And most people who are informed and know the law know securitization audits are basically worthless, and the courts have even called the auditors charlatans and their paperwork empty gimmickry.
Now, did lawyers commit legal malpractice by using these types of audits? And that's questions open to either one of you.
Well, I think it'd be better if Storm would address that.
Okay.
Well, we did a press release, Beware the Latest Foreclosure Rescue Scam Pretender Defenders, and in it, I already knew what the law was on it, but just for purposes of the press release and to quote it, I contacted several bar associations around the country, and I asked them all the same question. I said, because a foreclosure is basically an allegation the homeowners breached the contract, and that's the argument before the court, and when a court comes in a judicial state, when a bank comes in a judicial state, they basically tell the judge, here's the contract, here's where they haven't made payments, the contract says we could take the house, we want the house. So in contacting these bar associations, I asked the same question. If someone comes into an attorney's office in your state with a contract dispute, because this is what it is because the bank's alleging you breached it, and they fail to examine that contract for breaches, errors, tortious conduct, set-offs, and the like, is that malpractice? All of them use the same word, absolutely.
Okay. All right. Well, I want to take a quick break, and we'll be back in just a moment to talk more about securitization audits. Hang with us.
Our highly competitive and hectic world is fraught with dishonesty and challenges. Critical decisions must be made on a daily basis with accuracy when substantial assets are at risk. When you are confronted with a decision point involving opportunity and risk, consult with Sharpline Investigations, statewide experts in due diligence, investigations, and litigation support. Sharpline's professionals work with clients to conduct interviews, deep background investigations, and develop facts and intelligence related to litigation. When circumstances require confidential and expert fact-finding, turn to Sharpline Investigations, the statewide leaders in investigations and risk mitigation. Visit sharplineinvestigations.com or call 855-394-0042.
Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
Welcome back to the Half Empty, Half Full Talk Radio Show. My guests today are Bob Hurt, he's a consumer advocate, and Storm Bradford, who owns Mortgage Fraud Examiners. We've been talking about securitization audits, and basically you guys are telling me they're useless. I want to talk about specific cases in this segment. So, Storm, I'm going to start with you. Tell me a bit about a case called D'Amelio versus Citizens Home Loans.
Yes, this was the United States District Court case down in Georgia, and in that case, one of the parties tried to get into evidence one of these securitization audits, and the court said that this document was absolutely useless, and that this was nothing more than charlatans that were trying to take advantage of homeowners, and basically went on to say that their paperwork was empty gimmickry, and that there was no such thing as a as a certified forensic loan auditor, and went on and on about it, that it was just utter nonsense.
Now, years ago, actually, I think about the time I first spoke to you, Storm, was probably around 2009, and you might recall this. Through a friend of mine, I found a company because I had so many clients calling me, and I'm not a lawyer, and I had to direct them somewhere. And that friend directed me to someone who was a mortgage representative that was selling the securitization audits. Do you remember that?
I vaguely recall that. Yes, I do.
Right, and I remember one of the things you said was, well, how does the opinion, since it's not legal, weigh in because a mortgage person is doing it? And over the years, I know you've told me stories that just anybody would be coming up with the securitization audits because they were cashing in on the money because consumers weren't doing their due diligence, and lawyers, for them, hey, they're making more money. Not in all lawyers' cases, but that seemed to be the crux of it back then. So what would you like to add to that?
Well, we did a press release on securitization audits being scams years ago, and before we did the press release, I called up a couple securitization auditors that I knew, and I told them that I was going to do this press release, and I'd be willing to put any quotes into the article that they would like. I said, but first I'd like to ask you a couple of questions, and we can use those quotes. And I asked this one individual from this securitization audit company, I said, do you know of any securitization audit company that has ever, where a homeowner that used one has ever gotten financial compensation from a bank? His answer was no. I said, do you know of or have you ever had a homeowner that had gotten free title to their home? His answer was no. And I asked him, I said, then what good is this securitization audit? And he said, well, you could use it basically to stall, or if the homeowner had already been foreclosed on and the proper party didn't do it, it would upset the foreclosure. And I said, well, yeah, it would upset the foreclosure, but wouldn't you agree that the bank would just come back and re-foreclose? And he goes, yes, but at least you stalled it for that period of time. So I said, in essence, its best use would be to stall at best, which he agreed. After I sent him his quotes that was going to be in the press release, he told me, he goes, no, I don't agree for you to put that in there. I said, yeah, but that's what you said. He goes, yeah, but if you put that in there, I'll be out of business tomorrow.
Right. And that leads me to my next question, which is how do consumers or people that are in the situation of being foreclosed upon, how do they find the truth? Because what do? You go online and you Google. That can be very, very dangerous, to try and find someone. So how do you find the right source? And then if you go to an attorney, well, we covered that in last week's show with Bob a little bit about the security, about the trying to find the correct attorney and how they work. So how does a consumer find the truth?
Well, the first thing he has to do is simply start looking around, because eventually he's going to find some of the articles that I've written on this very subject. And, of course, I don't charge him any money, so he's going to be able to get the truth free. And second, he could ask the attorney, because if an attorney tells him that, oh, you need a securitization audit, and I'm not going to do anything for you unless you have one, that attorney is really putting his career at risk. Let me tell you what Gregory Brill, a Florida foreclosure defense attorney, said. He also operates in Virginia. He said, most securitization audits I've reviewed are inadmissible in a court of law. They contain a mere opinion of a layman without personal knowledge and direct experience as to what happened with a particular mortgage note after closing. Why pay a securitization auditor when you can have your grandmother provide an opinion as to what happened with the note and have her sign an audit report? And he says 95% of all cases, the information supplied by the audit is already publicly available or unavailable either to the homeowner or the auditor. So you can't get anything of value. Furthermore, Matthew Widener, a St. Petersburg, Florida attorney who does foreclosure defense, whom I would normally refer to as a foreclosure pretender defender, He wrote this on his blog: mortgage loan securitization audits are a crime. That information is useless if it's not admissible in court. So I issue the challenge once again. Will any so-called securitization expert please stand up? Please share with me admissible evidence of success in any foreclosure or bankruptcy case? Well, we know the answer to that.
Right. I mean, it seems like a hamster wheel. People are desperate. They're in a bad situation. You know, they're providing for their family. Now their house might be going to foreclosure. So they get desperate and panicky, and they start grabbing at straws, whatever looks like might match what their concept is of win, even if it's not reality.
Right. But let me point this out, okay? All of this leads us to the real crux. The real crux is, when does somebody ever ask for a securitization audit? Is when he's facing foreclosure. That's when he gets the bright idea that he needs one. So what is the natural question? Why does a borrower who defaults on a loan have any chance to beat a foreclosure with or without a securitization audit? Maybe Storm ought to address that.
Right.
Well, let me dovetail on what Bob said quickly, and to answer your question, Laurie, what does a homeowner do? How do they check this out? Well, one thing to do is when you hear something, is to go to Google it. For an example, if you Google securitization audit and scam, you're going to come up with tons of articles, including Bob, and you're going to come up with press releases. So that's one way to do it. The problem lies in the fact that there are literally thousands of these companies. And I was talking to a homeowner the other day, and she told me, she says, Storm, I've had at least 100 phone calls from securitization audit companies. I've also had direct mail, probably from another 100, pushing these securitization audits and basically telling me it's the only thing that will save my house. So they're being inundated with all of this misinformation. And the only way to check it out is anytime they hear some information, go Google it and put that information in and write scam next to it and see what the answer is.
All right. It's pretty heavy duty. Now, we got a couple of minutes before we go to break. So I want to ask about why a borrower defaulting on a valid loan can't beat foreclosure.
What about it, Storm? Why is it?
What was the question again? I'm sorry.
Why a borrower defaulting on a valid loan cannot beat foreclosure. Here's the reason why. And that is because the foreclosure issue is all about breach of contract. It's not about anything else. If the borrower breached it and he can't point out that the lender breached it first or someone else involved in the lending process breached it, then he's got no defense.
So he's automatically going to lose unless you can prove that the bank breached first or an agent of the bank breached first.
That's right. So what's the key, Storm?
Well, actually, to give you a quick scenario, I was on another radio program, and during the program, an attorney called in who's been an attorney for 48 years. And she told me that, she says, I didn't hear the beginning of the program. She says, Storm, you don't happen to be a judge in Georgia, are you? And I said, no. Why do you ask? She says, because this judge last week said verbatim when I was in front of him what you said on the radio today. And I said, what's that? She said, I was arguing to the Judge, this loan was securitized and MERS was involved. And the judge stops me and says, ma'am, what does any of that have to do with your client failing to make timely payments, thus breaching the contract? She goes, yeah, but Judge, you need to understand that the pooling and servicing agreement and the chain of title from A to B and C to T, and it never really got into the trust in time. And the judge stopped me again and says, ma'am, I ask you again, what does any of that have to do with your client breaching the contract by failing to make his payments? Please tell me that the other side breached first, or there's an error in the contract that would allow me to void it, or your client was fraudulently induced into the contract. Because if you can't, as a matter of law, I have to uphold that contract and allow the bank to take your home. She said, Storm, I said, that's exactly how it works. Unless you examine that mortgage transaction for breaches, errors, tortious conduct, set-offs, and in some instances statutory and regulatory violations, if it's there, which there are over 90% of the time, you're in good shape. You will save your house. If not, you're going to lose your home, because that's the only arguments that work. Nobody has ever won a case ever arguing securitization, produce the note, MERS, capacity to sue, assignment, so forth and so on. They've stalled them, but they've never won one. And winning one is when you get compensated by the bank and or get free title to your home.
All right, I want you to hang on to that thought. We got to take a quick break and stay with us. We got more to go.
Champions, my friends, and we'll keep on fighting till the end.
Are your credit reports a mess? Are debt collectors hounding you? Maybe you're in foreclosure or headed towards foreclosure and don't know where to turn. It's time to stop panicking. Take back control of your life. Make the first step by calling Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Mention the word radio for a free 15-minute consultation. Don't delay. Call today.
Our highly competitive and hectic world is fraught with dishonesty and challenges. Critical decisions must be made on a daily basis with accuracy when substantial assets are at risk. When you are confronted with a decision point involving opportunity and risk, consult with Sharpline Investigations, statewide experts in due diligence, investigations, and litigation support. Sharpline's professionals work with clients to conduct interviews, deep background investigations, and develop facts and intelligence related to litigation. When circumstances require confidential and expert fact-finding, turn to Sharpline Investigations, the statewide leaders in investigations and risk mitigation. Visit sharplineinvestigations.com or call 855-394-0042.
My friends.
Welcome back to the show. My guests are Storm Bradford from Mortgage Fraud Examiners and Bob Hurt, Consumer Advocate. Now, Storm, I'm going to go back to you on this and maybe to give me a parallel, because a lot of people don't understand what you're talking about. It's more legal. So let's put it in the context of I go to purchase a car, and I'm going to do some type of a contract to purchase that car at a dealer. And maybe afterwards they find something wrong with the car. Can you give me an analogy to that?
Yeah, let's say that you're driving down the street one day and you go by a lot and you see this beautiful cherry red Mercedes convertible and you say, wow, boy, I think I'd look good in that driving down the street. So you pull in, you stop in, and you ask about the car, and they tell you, well, this car was owned by a little old lady who just drove the car back and forth to church on Sunday, and it only has 10,000 miles on it. So based on what he told you, you buy the car. You finance the car, and after you have it, you take it in and you get it examined. And when they examine the car, it turns out there's not 10,000 miles on it, but 110,000 miles on it. And it wasn't owned by a little old lady. It was owned by a drug dealer because they found drugs in the quarter panel. Now, you stop making payments on it. The car finance company comes by. Tow truck comes by and tows your car away. Now, they want to sue you for the deficiency, the difference between what the car was worth and what you still owe on your financing. So they come to court, and they come in and they say, look, here's the contract, and here's where it says in the contract that if he didn't make timely payments, we could take the car. We took the car, we sold it at auction, and there's a difference between what he owes on the financing of about $5,000. Now, your argument is, Judge, not only I was fraudulently induced into the contract, and I was told that a little old lady owned it and only had 10,000 miles on it. Well, Here's the proof that it had 110,000 miles on it. Here's the proof that it wasn't owned by a little old lady. It was owned by a drug dealer because of the drugs that were found in the quarter panel. Not only do I want all my money back that I paid him, I want punitive damages to punish them for lying to me. That's how it would work as far as a corollary would be.
All right. Now, I want to go back. We were talking a little earlier, in these foreclosure cases about stall tactics. It seems that there are some attorneys who define the stall as a win, correct, versus actually winning a house or punitive damages or damages of any type, correct?
Go ahead, Bob. You want to tell them?
Well, the truth is, you could say that it's a benefit for the homeowner if you got to stay a little longer in the house. But in reality, it's actually having like a white elephant strapped to your neck because your debt just went up. The accrued interest is building. The legal fees are building. And eventually they're going to get the house anyway. Who's going to get it? The bank.
Right, but the lawyers don't tell that to their client, the homeowner.
Well, I think they do.
Okay.
I think they say eventually you're going to lose it, but we'll keep you in there as long as we can. Now, that'll be real good for you and your family. You won't have to hurry up and move out.
Okay.
And there are people who stay in the house for, 5-6 years, and they make payments to an attorney, but they don't make payments to the... But you know what? If they don't make payments to whom they're supposed to make it, it's crooked. I don't... Just because I'm a consumer advocate doesn't mean I advocate the consumer cheat business people who have worked hard to try to establish a business where they can help. There's a lot of money at stake here. That's not an open invitation for open season on lenders just because they happen to be very good at making money and very good at engineering a business deal. Borrowers have to go into business. They're adults. They need to go into business with their eyes wide open. And they need to realize that when they put their signature on that line, they are responsible to have read and understood everything in that document that they signed. And most people don't. They see a pile of documents and they just speed through them, signing them as fast as possible on the closing table. Well, that is irresponsible.
Well, it's the responsibility of both parties to understand exactly what the paperwork is, correct?
Well, that's right. And the banks take it seriously. They have lawyers that develop all this stuff for them to keep them out of trouble and make them in compliance with the law. Now, let's just suppose that a borrower had a good reason to worry. For example, suppose the borrower has a note that's got robo-signing on it.
Okay.
Well, what is robo-signing, Storm? And is that a valid argument in a foreclosure defense?
Well, robo-signing as it was defined was basically someone who was supposed to look at the loan file didn't, but signed off on that file as if they did. How that overcomes the fact that the homeowner breached the contract is beyond me and the courts, because all of the courts that have ruled on these types of arguments have all said it's utter nonsense, because what does that have to do with the client not making... How did that keep that homeowner from making timely payments?
Well, when they come up and say, yeah, but the note isn't valid, the note's not valid because this guy who claims that he has the right to foreclose, his name's not even on it. Or maybe it is, but the guy before him, well, his name was robo-signed. How can we even trust it? So what's the problem with bringing up an argument like that in a foreclosure dispute?
Well, as you said earlier in the day, that whoever has that note can foreclose. And matter of fact, some of the courts have even said that, I don't care if the note was securitized, fractionalized, homogenized, or pasteurized. Whoever ends up with that note can foreclose on that home even if it was burglarized. So at the end of the day, the UCC, which is the law in every state and the District of Columbia, has who can foreclose, and you don't even have to own the note to foreclose. You don't even have to hold the note to foreclose. So
yeah, I even have a quote here from the court, the Javahari versus J.P. Morgan Chase Bank in 2012, in which the court said this: the plaintiffs here do not dispute that they defaulted on the loan payments, and the robo-signing allegations are without effect on the validity of the foreclosure process. So looks like the judge agrees with you, Storm.
So it doesn't matter. You're saying even though it's a technical problem, it doesn't affect the main course.
It doesn't affect the fact that the homeowner breached the contract, and then the question always is, and this is what the court basically asks someone that makes this argument: how did this keep you from making timely payments?
Right, and you guys are saying
contract.
Yeah, and you're saying it doesn't. But let me ask you this: aside from that, if all these people robo-signed, how come none of them are in jail? How come there is no action against the banks collectively? Do you understand what I'm trying to get to?
Well, again, what difference does it make?
It doesn't for the homeowner, but I'm saying they're still being allowed to manufacture evidence.
Well, no. What difference does it make, again, what robo-signing was? What difference does it make if someone didn't review the file but signed off on the file as if they did? How was the homeowner harmed?
Well, they may not have. They probably were not harmed. But I'm saying that it's so
not harmed.
Right. It doesn't affect their case. It doesn't affect their case. What I'm saying is separately from that. If it's been going on for so long, why aren't these people who didn't do their job and are manufacturing evidence, why are they not in jail?
Well, the main reason is because, first of all, this is a private deal between two people, an assignor and an assignee. The borrower isn't one of those, so he's not a party to the assignment. Number two, neither the borrower nor anybody else is a third-party beneficiary of that assignment, nor is the borrower or anybody else injured by the assignment. Therefore, none of them have standing to dispute it or enforce it in court. It's that simple.
All right, I understand. Well, let me go back a little bit here on the securitization audits. So let's say that somebody who's listening, a homeowner or a consumer that's been listening, has utilized one of these securitization audit companies, which in essence are worthless. Who do you report them to? How do you get your money back? Are there agencies you can go to? What do you do?
Well, there's a couple of ways to do it. I mean, you could obviously have the mortgage transaction examined, and then show the problems with the transaction itself, and then basically what we do with our clients is we have them send us all of their documents to include any securitization audits, and then what we do is we show where the securitization audit is bogus, why it's bogus. And then they take that information. They can go to the Consumer Financial Protection Bureau. They can go to the Attorney General. They can go to the Federal Trade Commission. They can go to a lot of entities that will basically help them get their money back.
All right, because you know what I do? I Google the name of any company with the word complaint, fraud, or scam next to it, and I actually see what is popping up on that company, because fraud is so rampant nowadays. People don't realize it, and a lot of these homeowners, when they purchase these securitization audits, they may have done it online, and it may be in another state 2,000 miles away. And while you can complain to the Consumer Financial Protection Bureau and maybe the Federal Trade Commission or whatever the authorities are, what are your chances of getting back your money? What do you think?
Well, that's why you go to the Attorney General in the state that the individual performed that securitization audit in and file a complaint with them. And usually when you do that, the Attorney General, part of what they'll do in shutting that guy down is make him pay restitution to the people he's ripped off.
Tell me one thing, Storm. In your experience, what good does it do to file a complaint with the Consumer Financial Protection Bureau?
Now, because so many people are doing it, they get on average now about 5,000 complaints a month, and a lot of it is bogus complaints, complaints based on, they securitize my loan, and a lot of these ridiculous arguments and so forth, which wastes a lot of time. So, agencies obviously are only so big. When you're talking about complaints in the thousands, you got to try to answer these things. It creates a logistic nightmare. So it's good to file a complaint with the Consumer Financial Protection Bureau, but there's other ways to file complaints. We give a list when we do our examinations. We give a list on the last page of all the state and federal agencies that one can go to in order to file complaints, and some of them are quicker and faster on the draw than the Consumer Financial Protection Bureau because of the amount that they're having to deal with.
All right, we got to take a quick break. I want to go into this in a little bit more detail, so stay with us.
Keep on fighting till the end.
Our highly competitive and hectic world is fraught with dishonesty and challenges. Critical decisions must be made on a daily basis with accuracy when substantial assets are at risk. When you are confronted with a decision point involving opportunity and risk, consult with Sharpline Investigations, statewide experts in due diligence, investigations, and litigation support. Sharpline's professionals work with clients to conduct interviews, deep background investigations, and develop facts and intelligence related to litigation. When circumstances require confidential and expert fact-finding, turn to Sharpline Investigations, the statewide leaders in investigations and risk mitigation. Visit sharplineinvestigations.com or call 855-394-0042.
Are your credit reports a mess? Are debt collectors hounding you? Maybe you're in foreclosure or headed towards foreclosure and don't know where to turn. It's time to stop panicking. Take back control of your life. Make the first step by calling Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Mention the word radio for a free 15-minute consultation. Don't delay. Call today.
My friends,
Welcome back to the Half Empty, Half Full Talk Radio Show. Storm and Bob. Okay. Storm, let's go back to you for a moment. We were talking about, filing complaints with the different agencies. Now, as I recall, you've been instrumental in actually getting some of these companies shut down, correct?
Have. Matter of fact, one of the things that we do at Mortgage Fraud Examiners is not only do we examine these mortgage transactions, we identify the scams and the scammers out there and make it public. And we do as much as we can to try to put these people, get them closed down or put in jail.
All right, now let's talk a little bit about Mortgage Fraud Examiners, because you're the only, as far as I know, the only type of service that offers what you offer, correct?
Correct. There's a lot of people out there that say that they do audits. We don't do audits. When you go to the doctor, you don't get audited. You get examined. Audits deal with numbers. Forensic loan audits are, as we said earlier, known scams. Securitization audits are known scams. Again, the only proven methodology that works is attacking that mortgage transaction, looking for these breaches, errors, tortious conduct, and the like. The homeowners that have used our services and methodologies have received multi-million-dollar awards, dozens of free title to homes, and every conceivable settlement offer you can think of under the sun.
All right, let's start back at the beginning. How did you come up with the idea for Mortgage Fraud Examiners?
I didn't come up with it. Actually, we were kind of forced into it because, as I said, we've been providing litigation support service for over 35 years, and we just started getting an enormous amount of phone calls from attorneys around the country. How do you win these foreclosure cases? And we said, well, it's easy. This is a contract, and if the homeowner has breached the contract, you better find a way to void that contract or show they were fraudulently induced into it, or there's some sort of breach of it, or whatever the case may be. And we started out training attorneys on how to examine these mortgage transactions, but it was a long process. It took us a week. And then even after educating these individuals on it, they still didn't have the acumen to do it, because you have to have underwriting experience. You have to have experience with appraisals, whether or not, someone followed the USPAP guidelines in evaluating appraisals. Case in point, when we first started, had an attorney in New York who called and said that he knew this contract inside and out, but he wanted to test our acumen, and he said, I know what's wrong with this mortgage transaction. and we examined it for him, sent it back, and he told me afterwards, he says, I didn't find anything wrong with that mortgage transaction at all, and you identified 17 problems with it.
Okay, that's pretty impressive. So give me an example of some of the defenses that went, and let me ask one other question before that. Who is actually doing it? Are attorneys doing the legal examinations that work for mortgage fraud examiners?
Yeah, everybody that works here is either a practicing attorney, a retired attorney. We have different people on staff that do that. But to answer your question, we're not looking for defenses, we're looking for offenses.
Okay.
So, we're looking for how do we now take what we've found and use that against the bank? Now, this isn't me talking, this is the FDIC talking. The FDIC a few years back, they analyzed around 300 mortgage transactions and found that 83% of them were bad. They also did about the same number, examined the same number of appraisals, and found that 76% of them were bad. Well, when you take the 83% of the mortgages are bad and 76% of the appraisals are bad, you've got one hell of a shot that there's something wrong with your mortgage transaction. Now, our numbers are a little higher because we've done, I don't know if it's 2,000 yet, but we've done well over 1,000 of them. That our numbers just a touch higher. 90% of the mortgages are bad, and 80% of the appraisals are bad. But that's the information that the homeowner would take and either use it themselves or have an attorney use it and basically use that against the bank to overcome the fact that they breached the contract. Yes, I may have breached it. However, you breached it first. Yes, I may have breached the contract, but there's an error in the contract that voids the contract. Yes, I breached the contract. However, I was fraudulently induced into the contract. So, and just on and on and on. That's how, homeowners go about it.
Let me ask you a question about that, Storm. I field a lot of phone calls from people who have read my articles and they want help with their mortgage, they want an examination. And I tell them that if the examiners cannot examine what you don't give them. And some of them tell me that they have the full package of every piece of paper they've ever received having anything to do with that mortgage, any foreclosure, any bankruptcy, any forbearance agreement, any lawsuit, and so forth. And yet others, a surprising number of them, can't find the appraisal, can't find the loan package. They moved and lost it. Their house got burglarized or something, or burnt, and they lost it. There's so many excuses. How does a person go about recovering those documents that you need in order to do the examination?
Well, in most instances, anyway, the homeowner did not get a copy of the appraisal at closing. They just don't give them to you at closing. So the homeowner has to go to their servicer and ask for a copy of the appraisal that was used to do that loan transaction.
And what happens if the servicer simply doesn't want to give it up? Because that's what I hear most of the time. I tried, but they won't give me.
Well, I'm going to jump in here just for a quick second here. When I've had clients who've had that situation, I've directed them to the Consumer Financial Protection Bureau, which interestingly, on most other things like collections, takes about 3 weeks for them to get a response. But interestingly enough, when it's a homeowner in the foreclosure process and they file that complaint online, most of them get a response back within 1 day from the lender's counsel, usually offering up those documents. That's been my experience from clients that I've heard. But Storm might be different.
And you're right about that, Laurie. And the other thing, too, as well, is that what we tell the homeowner is look, you paid for the appraisal, so they have to give it to you. So what most people don't understand is when they call the bank, they're not talking to some bi-speckled gentleman with a gray flannel suit, white starched shirt, and a paisley tie. They're talking to some nitwit with purple hair, a razor blade in their cheek, that's making $7 an hour that can say no but can't say yes. So we tell them, we say, this is what you tell them. I paid for it. I want a copy of it. Get your supervisor on the phone. Of the couple thousand that we've done now, we have never, ever had a homeowner not able to get their appraisal.
They just might have to be more persistent than, average,
you just,
so to speak.
as we tell them, don't take no for an answer.
All right, give me an example of a successful outcome on one of your exams.
Well, we've had every type of successful outcome you can think of. We had a guy that out in the Midwest a couple of years back that we did an exam for, and he took the exam, wrote his grievance letter, sent it in, and called up afterwards and said, damn, Storm, this worked like a shot. He says the bank came back. They offered us $70,000 in cash, would knock our 7.65% loan down to 3.3% for the life of the loan, and knocked our property down to fair market value. This is the greatest thing since canned beer. So I said, well, you obviously didn't read the examination that we did. He goes, yeah, of course I did. That's how I wrote the grievance letter. I said, well, you didn't, because if you had, you would have known, because when we send our examination results back, we send them back electronically, because we'll have links within it showing court cases or statutes or so forth for them to look up. And I said, well, you obviously didn't read it completely or open the links up, because there's a court case there where these homeowners had the same bank as yours, same factual scenario as yours, only yours was worse, and they got millions.
But let me interrupt you. Are the settlements usually disclosed, or is it something an attorney can look up online for themselves?
No, what they do is that they always settle. Most of the ones, a lot of the people that we get, obviously, they haven't gone to court. They haven't. It's a non-judicial state, which most states are. Even in the judicial states, what they do is when the bank just comes back and offers.
Uh-oh. We just got cut off. Do we lose him? All right. Well, hopefully we're going to try and get him back. Some of the other scams I actually read about on Storm's website were mortgage elimination and lease buyback. Are you familiar with any of those?
No.
Okay, because mortgage elimination are companies that say, the money is not really the money, the straw man theory. That type of thing.
I have studied all of those so-called bogus arguments and agree that they're bogus, because in the end, let me put it this way. Let's suppose there's an argument that says the note provided the financial backing for issuing the loan.
Okay.
Well, that's nonsense. It's called the vapor money theory, and courts have denounced it across the United States. There's also the issue of there's no real money. Well, if that's the case, why does the borrower sign on his note a statement that says, for a loan I have received, I hereby promise to repay according to this schedule?
Well, people want to believe what they want to believe. They want to believe that they don't actually owe any money. So
now,
I
the
think
real
that's
point is, it's not just they necessarily want to believe it. Of course, people don't want to believe the hangman is putting the rope around their necks when it's happening. It's kind of like hard to take. But when a foreclosure bears down on someone, the best thing they can do is go get their mortgage examined by a competent professional like the mortgage fraud examiners, and once they have gotten it examined, then go on the attack. And the way to go on the attack is, number one, write the notice of grievance, go in and negotiate with the servicer, and then if he doesn't agree to go along with you, then sue him.
Great. Well, I want to thank you for being here. I'm sorry Storm got disconnected. I'm going to give out mortgage fraud examiners. Number is 844-920-7200. And Bob, your number is?
727-669-5511. And by the way, let's not forget that one of the benefits of using mortgage fraud examiners is they will train your lawyer for you.
Excellent advice. And join us every week for a new Half Empty, Half Full Consumer Advocacy Talk radio show. Learn something new and get smarter faster. Be safe.